the gentleman from Potawatomi, Representative Jacobson.
Good evening, Mr. Speaker, ladies and gentlemen of the House. During the debate tonight, I am unfortunately reminded that the opponents of this bill seem to be at loggerheads with themselves. At one point, they say parents don't want to make the decision. Within minutes later, they say parents do want to make the decision. At another point, they say the courts are the most appropriate, that we have the greatest court system, the envy. And then at another point, we're heard no judges want to be put in that decision. At one point, we're heard that healthcare providers should make this decision. Within seconds, it's an amorphous healthcare provider that's not defined. Let's take a look at the original bill, because this is a binary decision that we have tonight. Our bill says there's not the authority to withdraw life-sustaining procedures from a minor over the objections of their parents or guardians. As Representative Baxter said so well, this is about who has autonomy, the parents who brought this life into the world. How far we have come in a short amount of time. As you know, last summer there was a little boy named Alfie Evans in England who was not even actively dying, but the hospital ethics panel decided that this young man, even though not actively dying, just eating breathing treatments and food and water, that this was too costly and they were going to discontinue his treatment. And obviously, we know how that turned out for Alfie. Even though alternate care was available, they refused to release him to his parents. And everybody said, oh, this could never happen in Iowa. Well, how quickly we've moved this evening, folks. Let's take a look at the proffered amendment tonight. In the healthcare provider, is a reasonable medical judgment. What we're doing that was superior to the amendment is we're not allowing an amorphous healthcare provider, an insurance company, or the chief financial officer of the hospital or whoever, using reasonable medical judgment. There is a term that's not defined anywhere, unlike false artifact, and I'll get that later to you. What we're trying to do tonight is set up a due process standard. So we've got objective criteria to address this issue. What the amendment says was even to take over the authority from the parents and give it to the healthcare provider to even continue life-sustaining procedures. That means if we'd adopted this amendment tonight, food and water and breathing treatments could have been denied over the objections of the parents. This is absolute.
There is a point. Please state your point.
Thank you, Mr. Speaker. The amendment did not pass, and Representative Jacobson is talking about the amendment. We are on the bill.
Little lady from Story and the gentleman from Potawatomi, please approach well. Representative West Rochelle, your point is well taken. The amendment has been decided. We are on the bill. Representative Jacobson, you do have the floor.
So now we come back to Iowa and what's going on in Iowa. And I'm so appreciative of my good colleague, Representative Baxter, for personalizing this. We know many trisomy 18, trisomy 13 parents. Folks, I've got some really tough news for you. This is going on in Iowa. Again, children that are not actively dying, that in many situations need merely breathing treatments, respiratory treatments, food and water, are being urged by these very hospitals and hospital health panels to discontinue even basic life-sustaining treatments for their children. This bill protects the parents so that there cannot be a unilateral, arbitrary withdrawal of life-sustaining procedures over their objection. The parents have skin in this game. They're the one who brought these children into life. If not the parent, who's going to stand up for these children? Even more reason to protect the child with this bill. Now, Representative Masher made an excellent point. This is precisely why the false artifact language is in the bill. The false artifact language is in the bill so that in a felony murder situation, a crooked parent who may have been responsible for the child can't keep the kid forever on artificial life support. Thank you, Representative Masher. You made my argument for me. That's why that language is in the bill. And frankly, folks, please do due diligence. False artifact is there are so many medical journal articles and scientific journal articles on the false artifact situation that I could have brought a stack of papers in. Here were props allowed. Folks, this is giving an objective due process standard for the courts ultimately to arbit this if they need to. But what it does is during these elongated processes, it prevents a healthcare provider from arbitrarily withdrawing treatment, and then it's too late if the child's died and the due process happens after that. Why not err on the side of life if we're going to make an error? Even if the parents are in disagreement, why not err on the side of life? Folks, when we had this committee hearing, the ACLU lined up behind this bill. I have talked to multiple hospital administrators who certainly have a financial interest in this game. They are not against this bill. Ladies and gentlemen, I had advice from the ethics section of the Iowa State Bar Association writing the language of this bill. Ladies and gentlemen, if we were to do what the opposites want to do tonight versus what we are suggesting, by taking away parental authority for even life-sustaining treatment, meaning breathing and food and water, if we take that right away from parents, we're going way beyond where New York is in Vermont. We're moving from infanticide to pediicide, and it's damnable and it's despicable.
There is a point. Please state your point.
Way off the topic of the bill. Way off the topic of the bill.
It appears Representative Jacobson has yielded the rest of his time. Representative Meyer, does that satisfy your point?